Assalamualaikum warahmatullahi wabarakatuh. My name is Nurul Alia, matric number 281133, and I'm going to discuss about part 1, which is the case situation. This case is about Shafina Muhammad, which is the claimant, and Zil Cleaning Service, which is the respondent. The claimant, which is Shafina, has been appointed by the company as a call center executive at Zil Cleaning Services through a letter of appointment dated 15 October 2018. The appointment is effective 15 October 2018 with a probationary period which is 3 months. Thereafter, the company has issued a confirmation letter dated 1 December 2018 to confirm the appointment of the claimant as a call center executive. The issues that lead to the dispute are whether there is an existence of unfair labour practice in this case or not, unfair termination on the grounds of poor performance, coming late into work, and failing to achieve the fixed target by the claimant, which is Shafina Muhammad. The organizations, which is Zil Cleaner Services, are located at Beverly Hills Plaza, Kota Kinabalu, Sabah. This organization's nature of business is cleaning services such as cleaning the mattress, sofa, carpet, curtain, dust disinfection services, car polishing services, car seat cleaning, including housekeeping. The date that this case was first heard in industrial court was on 29 April 2019. Next is the chronology of this case. On 28 February 2019, the first warning letter was issued to the claimant due to her failure of reaching the monthly target. On 16 April 2019, the claimant was again issued the second warning letter for the illegal poor performance on 16 April 2019. Among others, stated that the claimant has failed to achieve the required 150 quota demo. Further allegation was that in the month of March 2019, the claimant also failed to achieve the 100 demo quota after being reduced. In the same second warning letter dated 16 April 2019, the company ordered that the claimant to achieve 110 demos for the month of April and 120 demos for the month of May 2019. The company also issued warning letter dated 29 April 2019 to the claimant for coming late to office every other day without specifying what day and time. The claimant was unlawfully terminated on 29 April 2019 without being paid for the 1 month salary. In this case, a domestic inquiry was illegally held on 29 April 2019. Since the company had conducted a domestic inquiry prior to the claimant's dismissal, it is therefore necessary to examine whether the company had complied with the rules of natural justice when it conducted the domestic inquiry. It must be noted that the illegal domestic inquiry was conducted on the same day the claimant's service was terminated from the company.
Hi and Assalamualaikum. My name is Athirah Johari. My matrix number is 281007. I will present about part 2 issues to be addressed. The claimant claims that her dismissal from the company had been carried out without just cause and excuse. The claimant also received warning letters for poor performance and arriving late to work. The claimant stated that achieve such a target had never been stated as a term in her employment contract or letter of employment. She admits that she received the verbal warning for coming late into the office. The company's decision to fire her was made without respect for equity, good conscience, resulting in an unfair dismissal.
The third part is the issues for the employees. The first charge is the company contended that there was a misconduct by the claimant. By coming late to the office, the claimant has failed to comply with the working hours and thus amounting to a misconduct as stated in Clause 7 with Clause 14 of the letter of appointment. The claimant responds that the company issued a warning letter dated 29th of April 2019 to the claimant for coming late to the office every other day without specifying what date, day, and time was it. The claimant was unlawfully terminated on 29th of April 2019 without being paid for 1 month's salary. The claimant's evidence is when the first witness testified that the claimant was really given a verbal warning by the first witness for the claimant's failure to come to the office on time. During cross-examination by the company, the claimant never disputed on this issue. She had admitted to receiving verbal warnings on the same. Her failure to be punctual and to observe working hours had not been in line with the Clause 7 of her letter of appointment.
The first issue is that the claimant had failed to carry out her responsibilities as the call center executive by her failure to achieve the fixed target demo of 150 demo per month. The claimant response is that the claimant has submitted that it was never stated as the term of employment in the appointment letter, neither it was part of a job scope to achieve the purported target demo. The claimant's witness is during cross-examination. The second witness was referred to the letter of appointment dated 15th of October 2018, particularly at paragraph 4 thereof, and she agreed that it is not stated that the claimant's job scope is to reach 150 target demo per month. The second witness also agreed that she is not familiar with the Mercy inquiry. The second issue is that the claimant alleged that the termination of her service was done arbitrarily without regards to the essence of equity and good conscience. The claimant's response is that she prays that this court holds that the termination done constitutes unlawful termination and or was in breach of the principles of natural justice and or was unfair labor practice and or was unlawful and or that the claimant was victimized. The claimant's evidence of incest is that the claimant testified that she was terminated by the company because of her failure to achieve the purported target demo fixed by the company. The claimant explained that it was never stated as the term of employment in the appointment letter, neither it was part of her job scope to achieve the purported target demo. As such, the claimant contended that she was unlawfully dismissed.
Part 4 issue for the respondent or employers. The first charge is the respondent submitted that there was misconduct committed by the claimant, particularly on the claimant's act of coming late to office. The first company witness testified that the claimant was duly given a verbal warning by company witness for the claimant's failure to come to office on time. By coming late to office, the claimant has failed to comply with the working hours and thus amounting to a misconduct as stated in Clause 7, read with Clause 14 of the letter of appointment. Further, it is also stated in the thumbprint machines report as per item 9 of the company's bundle of document that for the month of April 2019 that the claimant did come late to office on 2nd, 8, 16, 26 and 27 April 2019 respectively. The first issue is the respondent submitted that there was misconduct committed by the claimant, particularly on the claimant's poor performance. The respondent's statement on the issue of poor performance, the respondent contended that the claimant had failed to carry out her duty as call center executive by her failure to achieve the fixed target demo by the company. The respondent's evidence, the first company witness testified that a first warning letter dated 28 February 2019 was issued to the claimant due to her failure of reaching the monthly target. According to first company witness, a second warning letter dated 16 April 2019 was issued
to the claimant as the claimant still failed to perform the targeted amount of demo. The second issue is the claimant contended that she was unlawfully terminated and that her dismissal by the company was without just cause or excuse. The claimant alleged that the termination of her service was done arbitrarily without regard to the essence of equity and good conscience. As evidence, second company witness is the office manager of the company. She confirmed that there were warning letters dated 28 February 2018 and 16 April 2019 respectively issued to the claimant prior to her dismissal. And then she testified that the claimant was terminated due to her poor performance and coming late to office. According to her, the claimant had failed to reach the monthly target demo as expected and required by the company. She further testified that she confirmed that the claimant did come late to office 5 times for the month of April 2019. In example, on the 2nd, 8, 16, 26 and 27 April respectively. Before having the thumbprint machine, the attendance of the staff will be recorded via the group WhatsApp office. It can be seen from the screenshot of the WhatsApp group that the claimant was late to office on a few occasions. The first company witness also testified that the company then decided to do inquiry on 26 April 2019 against the claimant for her low performance and punctuality, but the claimant's response to the company's inquiry was far from satisfying. Next is part 5, the solutions to the issues based on Malaysian labour laws and codes. The first one is Employment Act 1955. The Employment Act 1955 Section 14 states that an employee can be dismissed on the ground of misconduct after due inquiry. This section of the law was interpreted to mean that a formal trial called a domestic inquiry should be held in the workplace before imposing the penalty of dismissal. Second is Industrial Relations Act 1967. Based on Section 20, Subsection 1, it is stated where a workman, irrespective of whether he is a member of a trade union or workman or otherwise, considers that he has been dismissed without just cause or excuse by his employer, he may make representations in writing to the Director General. The third one is common law. The first one is the manager should make an accurate diagnosis of the weakness in the worker based on the result of the worker's performance appraisal. Disciplinary action is only appropriate when all those factors have been taken care of and yet the worker still fails to perform, such as before an employee is dismissed for substandard performance, it is essential that he is informed that his work is not up to standard, and once he has been warned that his work is not acceptable, he must be given adequate time to improve. Next, management staff must be trained to identify and diagnose performance problems, to counsel employees and to draft warning letter. Second is employers shall have mutual trust and confidence with the employees. Both employer and employee owe each other a duty not to act in a way that is likely to destroy or seriously damage the relationship of trust and confidence between them. Next is duty to treat employee with respect and trust. Employees should be treated with respect and trust and not in arbitrary or vindictive manner. Next, we proceed to value. Value and concepts in industrial relation. The first one is justice versus equity. This concept and value are used to construct compensation structure and level as well as employees' termination and dismissal. Second one is integrity and trust. The quality of an integrity can be seen from the behavior that embedded from a consistent set of value. High trust. In this type of trust, the management is ready to accept ideas and opinions from its employee. The fifth one is Code of Conduct for Industrial Harmony 1975. The first one is training. The code lists training as one of the specific industrial relations practice. Adequately trained employees are essential for the success of the undertaking. Training appropriate to his work also helps the individual to develop his potential, to increase the satisfaction he needs in his work, and to improve his earning capacity.
Next, I will present about Part 6, Solutions to the Issues based on the Case Precedents or Case Law. Case 1, Medas Corporation Berhad versus Normawati Muhammad Nawi. The company avers that the claimant persistently late for work and did not carry out the instruction given by superiors. The company avers that the claimant was incompetent and inefficient as she had consistently failed to complete her task on time. The court finds that the reason for the termination of the claimant as follows. The claimant was guilty of misconduct as she was persistently late for work and did not carry out the task given by superior. She was inefficient and incompetent as she was consistently failed to complete her task on time. The award is the court finds that the claimant was dismissed for just cause or excuse.
The second case that is similar is Muhammad Hilmi bin Alham versus Burma's Motor Trading Sdn Bhd. The findings that I could find is the employee was terminated due to his poor performance as a result of his failure to meet the sales target that was specifically stated in his employment contract. The employee was also given various warnings about his failure to achieve his sales target. The company, by letter dated 4 April 2018, informed the claimant that his sales performance was below par and requested the claimant to improve on his sales performance. The claimant was also reminded of the sales target and cautioned that action will be taken against him if he fails to meet the sales target. The award for this case is the industrial court held that the employee was dismissed with just cause and excuse. Therefore, based on the foregoing reasons, the court holds that the company has proven on the balance of probabilities that the claimant is guilty of misconduct in the form of culpable, incompetent, and/or inefficiency. One should only apply and accept jobs he can do. The sales target was not imposed after the claimant had accepted the offer of employment. The sales target was found in the employment contract from day one when the claimant joined the company. The claimant's acceptance of the sales target when he took up the job, to my mind, is the culpability which permits the disciplinary of his inefficiency or incompetency.
The last past case is about Cisco Sdn Bhd versus Raja Mohan PB Limited in 2003. The claimant was the senior manager of Core System and Technology. The company terminated the employee due to his failure to achieve the company's sales target of 3 million. The claimant stated that these targets were not stated in his employment contract. The court is of the opinion that it is totally unjust for the company to consider that the work performance of the claimant was poor or unsatisfactory, since there is no documentary proof that the claimant had to achieve the specific target of 3 million as stated in paragraph 2 of the company statement. The award given is the Industrial Relations Court held that the dismissal of the employee was without just cause and excuse.
As a conclusion, the court is of the opinion that the company's decision to dismiss the claimant was without regards to equity, good conscience, and substantial merits to the case, thus amounting to the claimant's dismissal without just cause or excuse. Hence, our group decision is based on the analysis on the facts of the case, the acts, the common law and codes, and the values. It is best to agree with the court's decision to have ruled that the claimant was dismissed without just cause or excuse, as the company did not comply with proper procedure to inquire about any misconduct prior to termination.